constitutionally by splitting the seats in the National Assembly into 200-200 split. This challenge stems from Parliament's passing of the Electoral Amendment Act, which, amongst others, amended Item 1 of the impugned schedule to allow for independent candidates to contest for seats in the National Assembly. The primary remedy sought by the applicant is a combination of a striking down and reading in, which will result in the word half in Item 1A of the impugned schedule being changed with immediate effect to 350, and similarly the word half in Item 1B of the impugned schedule being changed to 50. The reading in will have, if successful, will have the effect of amending Item 1 of the impugned schedule to apply to the 2024 elections. In the alternative, the applicant seeks a suspension of the declaration of invalidity of the impugned schedule for a period of 36 months to allow Parliament to address the unconstitutionality and an interim reading in Item 1 of the impugned schedule in the manner set out in this paragraph. The application is opposed by the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, and the Minister of Home Affairs. The President of the Republic filed a notice of intention to oppose the application jointly with the Minister, but did not file an answering affidavit. The Independent Electoral Commission abides the decision of the court and has provided an explanatory affidavit. The Constitution itself does not specify the national and provincial election system. Instead, it outlines the requirements that the electoral system should comply with. These requirements include the need for the system to be based on a national common voters' roll, provide for a minimum voting age of 18 years, and result in general in proportional representation. The Constitution caps the number of seats available for contestation in the National Assembly at 400, and in turn, Sections 46.2 and 105.2 prescribe that national legislation must provide a formula for determining the number of members in the National and Provincial Assembly. Pursuant to these provisions, Parliament passed the Electoral Act, which regulates elections of the National Assembly and the provincial legislatures. From 1994 to 2019, the election of representatives in the National Assembly was based on a two-tier compensatory system, which filled the 400 seats in the National Assembly as follows. A, 200 seats were filled from regional lists submitted by political parties, and B, 200 were compensatory seats based on the national lists of political parties. During this period, only political parties registered with the Electoral Commission could contest elections. This meant that an adult citizen was not allowed to contest an election as an individual. Shortly before the 2019 general elections, the New Nation Movement, NPC, and its associates launched an entered application for leave to appeal directly to this court against a judgment of the Western Cape Division of the High Court, Cape Town. The High Court had dismissed an application to declare certain provisions of the Electoral Act unconstitutional insofar as they did not allow independent candidates to stand for elections. We heard the matter, and on 11 June 2020, this court in New Nation Movement NPC versus President of the Republic of South Africa held that the Electoral Act was inconsistent with the Constitution as it made no provision for independent candidates to contest elections for the National Assembly and provincial legislatures. The operation of the Declaration of Unconstitutionality was suspended for 24 months to afford Parliament an opportunity to remedy the defect, giving rise to the unconstitutionality. The Electoral Amendment Act came into operation on 17 April 2023. It, amongst others, introduced a 200-200 split amongst independent candidates, regional political parties, and political parties at national level. The applicant was not happy with the split and felt that the regional level should have been allocated more seats than the compensatory level. This is what caused the applicant to approach this court and launch an application for direct access and to challenge the provisions of the impugned schedule. In its view, 350 seats should be reserved for the regional tier, whilst 50 should be for the national level. The minister filed an affidavit in which he explained that after the New Nation judgment, he commissioned a panel of experts called the Ministerial Advisory Committee to produce technical proposals in response to the judgment. The MEC had to develop policy options on the electoral system that would cure the defects in the Electoral Act. After investigation and deliberation on different policy options, the minister preferred the policy option the MEC termed the minimalist approach. He instructed 4 independent advocates with expertise in constitutional and electoral law to prepare a draft amendment bill in line with that policy. The bill was published in the Government Gazette on 31 December 2021 as the Electoral Amendment Bill. On 13 April 2023, after public participation processes, the President signed the Electoral Amendment Bill and it was published in the Government Gazette on 17 April 2023, resulting in the Electoral Amendment Act, which contained the impugned schedule. In terms of this act, the allocation of seats in the National Assembly is still divided into equal halves. The first 200 seats referred to as the regional seats and the other 200 as compensatory seats. Independent candidates and political parties can both contest for the 200 regional seats, but only political parties can contest for the 200 compensatory seats. The amended Electoral Act therefore retains the two-tier system while providing an opportunity for independent candidates to contest elections for the National Assembly as required by New Nation 2. Whereas previously, one ballot determined the allocation of regional and compensatory seats in the National Assembly, voters will now receive 2 ballots, one to vote for a regional seat and one for a compensatory seat. The 200 seats in the National Assembly are allocated to 9 regions, which coincide with the provincial boundaries. The Electoral Commission determines the number of seats allocated to each region based on the number of registered voters in each region. A voter will receive a ballot paper specific to their region, which contains both independent candidates and political parties. That will be the regional ballot. A voter can vote for either a political party or an independent candidate on the regional ballot. All votes cast in a region will first be used to determine a provisional allocation of that region's regional seats to both independent candidates and political parties. If an independent candidate meets the relevant quota for 1 seat, they will be elected to the National Assembly. Even if an independent candidate gets sufficient votes to be provisionally awarded 2 or more seats, the candidate is only limited to 1 seat. This is because, unlike a political party, which has many candidates and may get many seats, that is not possible for an independent candidate, as they are contesting the elections in their individual capacities and are not affiliated to any party. Similarly, if an independent candidate contests for more than 1 region and wins seats in more than 1 region, they forfeit the additional seats in the other regions. The minister submits that that is the inevitable consequence of the choice made by a citizen to contest elections as an individual instead of doing so through a political party. Then there are the 200 compensatory seats. The voter in a region gets a second ballot paper listing only the contesting political parties. The compensatory ballot does not elect compensatory representatives directly. This quota takes into account all 400 seats in the National Assembly minus the seats allocated to independent candidates and is based on the total number of votes cast for the political parties in both the regional and compensatory ballots. The stated purpose of the compensatory seats is to correct the disproportionality in representation in the results of the election. Therefore, the new position after the passing of the Electoral Amendment Act is that 200 regional seats are filled by independent candidates and candidates from political parties, and the 200 compensatory seats are filled by candidates from the list of political parties only. Independent candidates are thus excluded from contesting for the compensatory seats. In its submissions to this court, the applicant did not object to the principle that independent candidates can only compete for regional seats, whereas political parties can compete for both regional and compensatory seats. The applicant takes issue with the fact that independent candidates can only compete for 200 regional seats and argues that independent candidates will, as a result, be required to earn more votes in order to secure a single seat in the National Assembly compared to political parties. The contention that candidates for regional seats will have to earn more votes than candidates for compensatory seats is based on an analysis by Mr. Michael Atkins in his report, whose expertise lies in the fields of mathematics and computer science. Briefly, Mr. Atkins' thesis is that, based on data from the 2014 and 2019 elections, independent candidates will require more votes than political parties to win a seat in the upcoming national elections. The applicant therefore seeks an order in terms of which the compensatory seats would be reduced from 200 to 50. As a result, those competing in the regional tier will contest for 350 seats instead of 200 seats. This will result in a 350-50 split as opposed to the 200-200 split contemplated in the Electoral Amendment Act. In a unanimous judgment penned by myself with Zondo CJ, Maya DCJ, Olapen J, Matopo J, Rogers J, Skipast AJ, Theron J, and Fansale AJ concurring, this court held that the circumstances of this case are exceptional and that the application raises legal issues of fundamental importance relating to the fairness of the 2024 elections, and that the time is of essence since the 2024 elections are imminent. Therefore, direct access must be granted. Regarding the merits of the application, it is tried that in order to pass constitutional muster, the exercise of public power by the executive and other public functionaries must at the very least comply with a threshold of rationality. As long as the purpose sought is within the authority of the functionary, as long as the functionary's decision is rationally connected to that purpose, a court cannot interfere with the decision simply because it disagrees with it. The applicant admits that the 220 split is irrational and inconsistent with the rule of law, and therefore contravenes Section 1C of the Constitution. It also argues that the irrationality stems from the quota for regional seats being much lower than the quota for compensatory seats. The respondents submit that the Electoral Amendment Act is rational in that the two different methods used by the Electoral Amendment Act to fill regional and compensatory seats legitimately differentiate between independent candidates and political parties for the express purpose of achieving proportional representation and avoiding the risk of overhang. The rationality of the 200-200 split, I beg your pardon, therefore hinges on whether A, it results in proportional representation in general, and B, avoids the risk of overhang. Section 46(1)(d) of the Constitution requires Parliament to design an electoral system that results in general in proportional representation. There are 400 seats available for contestation in the National Assembly, which in terms of the impugned schedule are divided in half, 200 regional seats and 200 compensatory seats. The stated purpose of the 200 compensatory seats, according to Parliament, is to correct this disproportionality in representation in the results of the election. Parliament contends that proportional representation systems are in general subject to distortions with the introduction of independent candidates. This is so because irrespective of how many votes an independent candidate receives, they are restricted to a maximum of 1 seat. According to Parliament and the Minister, the only way to include independent candidates in a two-tier system while retaining proportional representation is to allow them to retain the seats they win and obtain proportionality by allocating the remaining seats to the parties that gain representation. The applicant accepts that the 200-200 split results in general in proportional representation. This is also accepted in the Applicant's report filed in support of the applicant's case. The respondents accept that a 350-50 split as proposed would also achieve proportionality in general. The applicant also acknowledges that reserving compensatory seats for political parties is necessary to achieve proportionality because the formulas for regional seats have the potential to distort proportionality, and this potential has increased because independent candidates can now contest for regional seats but can only hold 1 seat. Properly construed, the dispute between the parties is therefore not whether it is irrational for Parliament to distinguish between regional and compensatory seats in the National Assembly. Rather, the dispute concerns the number of compensatory seats that ought to be reserved for political parties, with the applicant proposing a 350-50 split on the basis that the 200-200 split debases the value of votes for regional seats. Even if the 350 split proposed by the applicant might arguably be fairer and achieve proportionality, Sections 46(1) and 105(1) of the Constitution expressly leaves the choice of electoral system in Parliament's hands. Wide latitude is given to Parliament to consider the manner in which to conduct the electoral system, at least on the requirement of achieving proportionality. The 200-200 split chosen by Parliament passes constitutional muster. The second stated objective of the 200-200 split by Parliament is that it avoids the risk of overhang. The Electoral Commission explains that overhang is when more seats are required to be allocated to restore proportionality, as between represented parties after the allocation of regional or constituency votes than are available in the legislature. The applicant contends that the 350-50 split will bring the quota for a regional seat closer to the quota for a compensatory seat without posing a significant risk of overhang or disturbing the proportional representation of political parties. To verify this proposition, the applicant relies on the Atkins report. Mr. Atkins ran a Monte Carlo simulation of elections in terms of the Electoral Amendment Act based on the 2014 and 2019 election results. According to the Atkins report, the 350-50 split gives rise to a foreseeable risk of overhang of up to 15% per election based on the 2040 election data, limited to 1 seat. The applicant argues that while foreseeable, the risk under the 350-50 split is remote and limited to 1 seat. On the 200-200 split, however, there is virtually no risk of overhang, with the only recorded risk found in the Atkins report being at 0.03% at 6% support for independent candidates in respect of 1 seat based on the 2014 election data. Considering the above, on the 200-200 split, there is virtually no risk of overhang. As a result, Parliament's second stated objective of the 200-200 split to avoid the risk of overhang is achieved. The Electoral Commission explained that there is no mechanism under the current Electoral Act to correct the problem should overhang occur. The applicant has also not presented any viable solution to combat the risk of overhang or remedy should it occur. Furthermore, overhang poses the risk that the Electoral Commission would not be able to declare the election should the risk materialize. Even if the risk is as remote as proffered by the applicant, the consequences are severe as explained by the Electoral Commission. Consequently, the foreseeability of overhang under the 350-50 split as proposed by the applicant is potentially destructive to the applicant's case. During the hearing, the applicant submitted that the method utilized at the municipal level to prevent overhang offers a potential solution to the risk of overhang in the 350-50 split. This submission was made for the first time during the hearing. It is well established that parties in motion proceedings should make out their case in their founding or answering affidavits and not in their heads of argument or in the course of the hearing. The exception to this position was articulated by this court in My Vote Counts, NPC, versus Speaker of the National Assembly, where Kampepe J held a point that has not been raised in the affidavits may only be argued or determined by a court if it is legal in nature, foreshadowed in the pleaded case, and does not cause prejudice to the other party. In the present case, this exception does not apply. The proposed solution to the risk of overhang, which the applicant proffered in the hearing, is not legal in nature, nor was it foreshadowed in the applicant's pleaded case. While no weight is attached to the applicant's proposed solution to the risk of overhang, it must be stressed that although the 200-200 split is rational in that it avoids the risk of overhang and ensures proportional representation, this should not be interpreted as an indication that overhang will always be an insurmountable challenge. The risk of overhang arises because, like the Electoral Act, the Electoral Amendment Act prescribes that the full 400 seats of the National Assembly must be available for contestation. This is the maximum number of seats that the Constitution prescribes. Should the number of seats available for contestation in Parliament be reduced to a number above 350 but below 400, it may be possible to allocate overhang seats and increase the number of seats in the National Assembly by the number of overhang seats up to 400 until the next election. This is how the New Zealand Parliament addresses the risk of overhang. Secondly, unlike the Local Government Municipal Structures Act, the Electoral Amendment Act does not provide a formula to address overhang should it arise. I recognize that the absence of a formula to address overhang in the Electoral Amendment Act may well be as a result of the fact that there is no risk of overhang on the 200-200 split. I refer to the Municipal Structures Act to illustrate that the risk of overhang is not a novel concept in South Africa, and that the legislature has, in the context of local government elections, provided a mechanism to deal with it should it arise. In the result, on the facts and submissions, the 200-200 split passes the rationality test as it achieves proportional representation and avoids the risk of overhang. We thereafter consider the issue whether the electoral scheme has infringed any fundamental rights in the Constitution. The applicant contends that the 200-200 split is unconstitutional as it violates sections 1C, 32A, 9.1, 19.2, 19.3, and 46(1)(d) of the Constitution. In view of the conclusion that the split is rational and achieves proportional representation in general, the applicants challenge that the provisions of sections 1C and 46(1)(d) are infringed falls to be dismissed. The applicant further argues that the 200-200 split violates section 32A of the Constitution in that a vote for an independent candidate carries less weight than a vote for a political party. In reaching this conclusion, the applicant's report rests on the assumption that voters who vote for a political party in the regional ballot will vote for the same party in the compensatory ballot. The applicant also submits that the split violates section 9(1) of the Constitution in that it arbitrarily differentiates between independent candidates and political parties. In New National Party versus Government of the Republic of South Africa, the applicant in that case argued that the requirement of a bar-coded identity document excluded eligible voters who did not have a bar-coded identity documents, and that this breached section 9(1) and 9(2) of the Constitution. In considering this argument, Jacob J. said the following: "It is clear from what has been said in this judgment that although the documentary requirements in issue may be said to differentiate between different categories of people, there is a rational connection between the measure and the legitimate governmental purpose of facilitating the effective exercise of the important right to vote. No discrimination or unfairness has been established." In Democratic Party versus the Minister of Home Affairs, this court had a similar application as in New National Party. Goldstone J. for the majority held that in the absence of evidence showing that the impugned provisions have had the effect of infringing on the right to equality as suggested by the Democratic Party, it cannot be found that the provisions on that account were unconstitutional. This court therefore rejected the Section 9 equality challenge in Democratic Party and in New National Party on the basis that A, there was a rational connection between the measure adopted by Parliament and the legitimate governmental purpose, and B, the applicant failed to provide evidence to support the alleged inequity. In United Democratic Movement versus President of the Republic of South Africa, this court held that the fact that a particular system operates to the disadvantage of particular parties does not mean that it is unconstitutional. Similarly, in Democratic Party, this court held that it must be accepted that there are very few laws of general application that will not directly or indirectly have the potential to affect different categories of people in different ways. From this court's judgments, it is therefore clear that a law affects different categories of people differently. A law that affects different categories of people differently does not prove a violation of the right to equality as provided in Section 9 of the Constitution. The person alleging the violation should provide evidence to support the alleged violation. The proposition that a vote for an independent candidate carries less weight when compared to a vote for a political party is without merit. Independent candidates and political parties compete for the same quota in regional elections, and votes carry the same weight. There is no differentiation in respect of regional seats. The applicant's argument that the Electoral Act, as amended, devalues a vote for an independent candidate is based on the assumption that a voter that votes for a political party will vote for the same party on both the regional and compensatory ballot, which in turn means that independent candidates need double the votes needed by political parties to gain a seat in the National Assembly. By parity of reasoning, vote splitting beyond a de minimis trivial level by voters who vote for political parties would be fatal to the applicant's rights violation challenge. While the 2024 national elections will be the first elections South Africans will get to vote using 2 ballots for the National Assembly, it is not inconceivable that voters may choose to split their regional and compensatory votes. There is in fact evidence of vote splitting by South African voters in the last provincial and national elections. When one considers the 2019 provincial and national elections in South Africa, there were no cases where the party-specific vote totals for the national and provincial votes corresponded exactly. Further, the Electoral Commission explains that in municipal election, where independent candidates stand for political election as ward candidates, most voters that support independent candidates also choose to support a political party on the second ballot. Notwithstanding the aforesaid, I do not think that an electoral law could ever be properly formulated on the basis of an assumption as to how people will vote, as applicant suggests. An electoral law must always assume a complete freedom for the electorate to vote as they please, including splitting their vote where an opportunity to do so exists. In conclusion, the applicant has not been able to prove that A, the split is arbitrary, and B, a vote for an independent candidate carries less weight. Bearing in mind that the mere difference in effect of the split is not in and of itself evidence of unequal treatment in the manner protected against in the Constitution. Therefore, the applicant has failed to discharge the onus of proving the model articulated by Parliament infringes on the equal protection provisions provided for in sections 3(2)(a) and 9(1) of the Constitution, as alleged. For these reasons, the section 3(2)(a) challenge also fails. The next issue relates to the argument that the 200-200 split violates sections 19(2) and 93 of the Constitution, in that it undermines the fairness of the outcome of the elections, and that the split violates the right to vote and to stand for public office. The applicant submits that the 200-200 split infringes on the right to equal benefit of the law and the right to stand for public office, as votes for independent candidates weigh less than votes for political parties, and makes it more difficult for an independent candidate to be elected. In ex parte Minister of Safety and Security, in Re S. versus Walters, this court set the test for examining whether an enactment violates a right in the Bill of Rights, and held that this entails examining A, the content and scope of the relevant protected right, and B, the meaning and effect of the impugned enactment, to see whether there is any limitation of A by B. In the present case, the content and scope of the relevant protected right refers to the political rights protected under section 19(2) and 19(3) of the Constitution. This court's jurisprudence shows the importance of political rights in light of our history of political exclusion, and the right to vote and the right to free and fair elections are closely linked. While the right to vote gives content to the right to free and fair elections, the right to free and fair elections has implications for how the right to vote must be exercised. This court in Camp versus Electoral Commission distilled elements fundamental to free and fair elections as protected under section 19(2) of the Constitution. These elements include A, persons entitled to vote should be registered to do so, and B, the protection of the right to participate in elections as a candidate and to seek public office. In my view, the elements distilled by this court in Ham are met under the 200-200 split. The Electoral Amendment Act entitles every adult citizen to a vote, and they can, in keeping with this court's ruling in New Nation, to vote for either a political party or an independent candidate. The Electoral Amendment Act also allows citizens to stand for political office and hold office if elected. The contention that a vote for a political party counts double to that of an independent candidate, which, as applicant argues, leads to a limitation of Section 19 rights, is, as I have already demonstrated, without merit. This argument is based on the assumption that voters will not split their vote, an assumption which I have already shown to be unsustainable. The applicant was required to show that the measures adopted by Parliament constitute a limitation of the political rights alleged. For the reasons stated, the applicant has failed to discharge these onus, and as such, the 200-200 split passes the second leg of the Walters test. It follows that the Section 19 challenge must also fail. Due to this conclusion, it is not necessary to conduct the justification analysis under Section 36 of the Constitution, as I have concluded that the impugned schedule does not violate any of the fundamental rights alleged by the applicant. To sum up, the applicant has not established that the impugned legislation is irrational, nor that it infringes a provision in the Bill of Rights. Therefore, it has not made out a case to justify the declaration of constitutional invalidity. It follows that the application must be dismissed. Following the principle set by this court in BioWatch Trust versus Registrar Genetic Resources, each party must pay their own costs. In the result, the following order is made. 1, direct access is granted. 2, the application is dismissed. 3, there is no order as to costs. I hand down the judgment.
As the court, please.
Thank you. You may call the next case.
The matter of one European South Africa APC and President of the Republic of South Africa in Athens for judgment.
May it please the Court Justices, I confirm my appearance on behalf of the applicant.
Thank you.
May it please the court, I appear for the Electoral Commission in this matter as well.
Thank you.
May it please the court. I appear on behalf of the first, second, fourth, and fifth respondent.
Thank you.
Thank you. In this matter, there are 3 judgments. 2 deal with the signature requirement and 2 deal with what has become known as the recalculation challenge. What I will do is provide an overview of the case and the factual and legal issues that underpin it, and then deal briefly with the thrust of the 3 judgments before dealing with the order. I'll proceed. Today, this court hands down its judgment in an application for direct access brought by the One Movement South Africa, OSA, on an urgent basis that was heard by this court on the 29th and 30th of August 2023. The application was brought against the President of the Republic, the Minister of Home Affairs, the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, and the Independent Electoral Commission. In 2020, this court handed down its judgment in New Nation Movement, in which it declared the Electoral Act of 1998 inconsistent with the Constitution and therefore invalid insofar as it did not allow an adult citizen to stand for public offices independently of a political party. This court suspended that declaration of invalidity for 24 months to afford Parliament the opportunity to correct the constitutional defect that this court had identified in that case. In response to the New Nation Movement, Parliament passed the Electoral Amendment Act number 1 of 2023 in February 2023, which made it possible for an adult citizen to stand for public office independently of a political party provided that such candidate met certain conditions or complied with certain requirements. Apart from asking for direct access and that the matter be dealt with on an urgent basis, OSA mounted 2 constitutional challenges to the Act. The first challenge was directed to the provisions of Section 31(b)(3), which require an independent candidate and a political party, that is, a political party that is not yet represented in the National Assembly or in any provincial legislature, to secure and produce supporting signatures of registered voters in the relevant region amounting to 15% of the quota of the relevant region in the preceding election in order to be allowed to contest an election. For convenience, I shall refer to this as the 15% signature requirement. A quota is the total number of votes that a political party or independent candidate must obtain in an election in order to get 1 seat. The second constitutional challenge mounted by OSA relates to those provisions of the Act which prescribe how the recalculation of allocations of seats is done whenever a seat in the National Assembly or a provincial legislature previously occupied by an independent candidate becomes vacant, either as a result of death or resignation. The relevant provisions are item 11F of the amended Schedule 1A, which relates to a seat in the provincial legislature, item 5I of the amended Schedule 1A, and item 23 of Schedule 1A. OSA's second challenge will be dealt with shortly. It is necessary to deal with the first challenge first. OSA's first constitutional challenge was that the 15% signature requirement constituted a barrier for independent candidates who wished to contest elections. Although this was not spelt out clearly in OSA's papers, it seems that part of its complaint was that the 15% signature requirement was too high and that the requirement should be replaced by a requirement of 1,000 signatures. The regulations under the Electoral Act include provisions that require that a political party should produce 1,000 signatures of registered voters who support it when it seeks to register with the IEC. This is a registration requirement. The 15% signature requirements applies to independent candidates and new political parties when they want to contest elections. OSA contended that the 15% signature requirement detrimentally affects independent candidates' right to dissociate, their right to make political choices, their right to stand for public office, their right to dignity, and the right not to associate with the political party system by running as an independent candidate. The Minister of Home Affairs and Parliament opposed OSA's application to have certain sections of the Act declared constitutionally invalid. They did not oppose the application for direct access and that the matter be dealt with on an urgent basis. The IEC did not oppose OSA's application and filed a notice to abide the decision of this court. It also filed an explanatory affidavit to assist the court. The Minister, Parliament and the IEC set out how, over an extended period, the signature requirement moved from 50% of registered voters in the relevant region to ultimately 15% as decided by Parliament. They explained that the 15% signature requirement applies to both independent candidates and new political parties, but did not apply to political parties which were already represented in the National Assembly or in a provincial legislature. Parliament, the Minister and the IEC explained in their respective affidavits that the purpose of the 15% signature requirement in the Act is to ensure that independent candidates and new political parties which contest elections would be those who have a serious and have a credible prospect of obtaining at least 1 seat in the elections. OSA did not dispute that this is the purpose of this 15% signature requirement. Parliament, the Minister and the IEC also stated that there was a rational connection between this requirement and a legitimate government purpose. Parliament, Minister and the IEC made it clear that the 15% is the 15% of the quota of a region or province in a preceding election. In this regard, Parliament had decided to use provinces or regions as constituencies. They also pointed out that Parliament had decided not to use a fixed number of signatures, such as, for example, 1,000, but decided to use a percentage of a quota. In this regard, Parliament had decided upon 15% of a quota of a region. That's so much by way of background. This matter has produced, as I indicated, two judgments in respect of the 15% signature requirement. The first judgment is penned by the Chief Justice. The second judgment is penned by myself. There is also a third judgment to which I made reference to, and that is penned by Thoronje, and that deals with the recalculation challenge. I now proceed to deal with the first judgment. The first judgment holds that OSA made out a case for direct excess and for the matter to be dealt with on an urgent basis. The first judgment therefore grants direct excess. On the 15% signature requirement, the first judgment points out that although OSA contended that this requirement is an unfair barrier, OSA did not substantiate this contention so as to show why it was contending that the requirement is a barrier and why it was contending that the requirement is unfair. The first judgment also refers to the fact that in its founding affidavit, OSA said that its chief complaint was that Section 31B3 required both independent candidates and new political parties to comply with this 15% signature requirement, but that OSA did not substantiate this contention either. On this analysis of OSA's founding affidavit, the Chief Justice reasoned that OSA's real complaint was about the size of the regions or provinces and Parliament's decision to use provinces as constituencies. The first judgment points out that the regions or provinces had vastly different sizes, and as a result, they had different quotas. The first judgment highlights the fact that the bigger a province or region, the higher its quota, and therefore the higher the number representing 50% of the quota of the region. The smaller the province or region or constituency, the lower the quota required to get one seat, and the lower the number representing 15% of the quota. The first judgment says, if the quotas were low and the 15% translated into a number as low as 1,000 or 3,000, OSA would probably not complain. The first judgment points out that OSA does not ask this court to invalidate Parliament's decision to use provinces as constituencies. In his judgment, the Chief Justice highlights the fact that OSA said that its chief complaint was that Section 31B3 of the Act required both independent candidates and new political parties to comply with the same requirement, namely the 15% signature requirement, but did not anywhere in its founding affidavit elaborate on this to substantiate it. In other words, OSA did not say what was wrong with the Act requiring both independent candidates and new political parties to comply with the same signature requirement. The first judgment points out that during the hearing, this had been put to counsel for OSA to enable her to point out the substantiation, but she had not been able to do so. The first judgment also states that although OSA contended that the signature requirement was an unfair barrier for independent candidates wishing to contest the elections, OSA also did not elaborate on this so as to show why it was contending that the requirement was a barrier or an